Good afternoon, everyone. Thanks for joining. We're just going to wait a few moments to allow other participants to join. So if you could just give us 30 seconds or so, and then we'll begin the webinar. So I think we can probably start. I can see a number of participants here. Thank you so much for joining us for the third of our 4 sessions on fighting racial injustice for children in the criminal justice system. Aika has asked me to chair this session. She's chair of the advisory group for this piece of work, but she's going to talk on child criminal exploitation a little later, particularly around county lines and how race plays into that. I can think of a few better people to learn from, along with Dr. Grace Robinson and Danielle Manson. So what we lose from Aika chairing, we gain from their teaching. Those who've attended these sessions before know we've had some of the leading voices from across the world speaking on issues of race, children, and criminal justice. We've learned about unconscious bias, adultification, racism at the police station, and actions that can be taken against the police as just some of those topics. Today, as in the other sessions, we have an extraordinary lineup of speakers that I'm excited to learn from, and I'm looking forward to them sharing their wisdom and experiences with you. I am Shauneen Lamb. I'm the co-founder of Just for Kids Law, which I set up with Aika Stevenson 16 years ago. Since those early days, Just for Kids has been providing specialist representation to children in the criminal justice system. I'm now the Director of Impact Law for Social Justice, but I remain a senior legal consultant at Just for Kids. The issues that Just for Kids staff deal with today are the same as they were when we began 16 years ago. And I'm sure as practitioners, the same is true for you. But at least now there seem to be some opportunities to raise and challenge racial inequity. And we hope that with the guides that have been created and with these trainings, we'll be able to give you the tools to challenge the issues and the prejudices that we all experience in our practice. In the early days of Just for Kids, I think it was 2005 or 2006, Aika and I represented a young boy who recorded on his phone a police officer saying to him, "I'm going to smash your fucking Arab face in." The police, in that case, insisted on continuing prosecuting the boy for threatening words and behaviour. They didn't know there'd been a recording. It was the early days of mobile phones, which was released to the media and caused the media's storm at the time, with even the Commissioner of the Police, Ian Blair, getting involved. Had our client not recorded it, we can assume that he would have been found guilty of the offence. The officer said to the child at the time, and this was recorded, "This isn't one that you will fucking get off at court because I'll write it up properly." The officer himself was subsequently prosecuted after our client was acquitted, but as is often the case, the police officer was acquitted by the jury. In those days, county lines exploitation was not seen as exploitation at all, although we saw many of the same kinds of issues and clients being exploited. So although it often feels that we are caught in a perpetual cycle, looking through the long arc of history, as Martin Luther King would say, we can see some progress. The aims of these 4 sessions are to accelerate that arc of progress. The issue we have chosen to train on were identified by Just for Kids Law clients. These issues, the young people themselves identified as exacerbating race in the criminal justice system. So this evening you will learn best practice in representing children who may have been exploited through county lines operations, how expert evidence can help in light of potentially unhelpful Court of Appeal decisions, Bracani and AAD, and how to address discrimination in bail and remand decisions, and how to tackle racism in sentencing. We are, as always, grateful to the young people who share their experiences and ideas, and we feel privileged to work alongside them. and to amplify their voices in bringing about changes to the system. And although it's not a race-related issue, it seems important this week to remember Sarah Everard and what policing can mean for many people. So I'd just like to end my introduction with a quote from Caleb Azuma Nelson's extraordinary book, Open Water, and would recommend that all of you read it because it's such a powerful, poetic voice of what it means to be stopped by the police and constantly under police scrutiny. He says, "You tell no one about that incident, like you told no one about the time they stopped you hard. Your friend was driving, one hand on the steering wheel, the other gesticulating as he preached. He pulled over, and that's when you heard a screech, squeal, scream of tire. Drowned by screech, squeal, scream of get out of the car, get out of the car, get out of the car. They ordered you to the ground for symbolic purposes, playing dead. You let out a skinny whimper, sharp as a butter knife. You heard the sound rattle in your chest, pressing shut unserious features, total eclipse. When you came to, you were beside yourself. This is what it means to die, you thought, total eclipse. The sky turned black. Ha! You looked in one of their eyes and saw the image of the devil. He had an index finger gripping the trigger, like he was holding onto a lifeline. He looked scared behind the crumpled forehead, the hard eyes. He looked scared. He looked scared of what he did not know, of what was different. He looked scared because instead of questioning himself, of interrogating his beliefs, of not filling in the gaps, he continues to look at you as a danger. You fit the profile. You fit the description. You don't fit in the box, but he has squeezed you in. He looks scared. They all did. You wouldn't accept their apologies nor their extended hands, because even these are weapons in the darkness. So just before we begin, a couple of housekeeping issues. We really want these trainings to be interactive, so please do ask our experts questions. If you put any questions in the Q&A rather than the chat, then they will head my way. We hope to develop a rich conversation in the space about these issues, and a copy of the guides will be uploaded into the chat. If you have any questions after the event, please don't hesitate to contact YJLC. And if you'd like personalized training for your staff or organization, YJLC would be more than happy to provide it. Now it gives me great pleasure to introduce my co-founder at Just for Kids Law, legal director and phenomenal youth justice lawyer, Ika Stevenson. As I mentioned, Ika and I founded Just for Kids Law and then ran the youth justice practice at Lawrence & Co Solicitors. We subsequently moved to Hodge, Jones & Allen until we got our own legal aid contract in 2017. Since then, Ika has been heading up the legal team while continuing to represent children in criminal proceedings. A vast number of her cases involve some kind of criminal exploitation, and she's developed an expertise in first instance representation for these children. I'm always learning from Ika, and I'm sure this afternoon is no exception, and that we will all learn the best cutting edge ideas on how to represent children who might have been exploited in light of the current legal position. I'll hand over to Ika now.
Thank you, Shawneen. I'm slightly nervous now because of that intro, but I do have some slides to share which set out the law in relation to exploitation, so that those of you who are not litigating this regularly have something to refer to. However, as we're talking here about racial injustice, I want to focus more on the issues we face when representing Black children who are victims of CCE and provide practical advice rather than educate on the law. So just to run through the slides, we've set out here what CCE is. So if I could have the first slide, Bianca. It's not moving. Okay, thank you. So CCE occurs where an individual or group take advantage of an imbalance of power to coerce, control, manipulate or deceive a child into criminal activity. We have Dr. Grace Robinson with us, who'll be going into much more detail later about the features of CCE. So I think I'm just going to leave that there for now, but just as a way of explanation as to what we're talking about here. Next slide, please. So the defence is set out under Section 45 of the Modern Slavery Act. And I think the most tricky area is the reasonable person test, because race is most certainly at play here, particularly as the majority of jury members are white. Yet we can't cite race as a characteristic in itself that may impact the decision-making of a young person groomed into county lines. Now, myself and Danielle, who is part of the panel today, experienced this firsthand when we had, we just recently litigated a modern slavery case in front of a jury, and it was quite clear that young person had been believed in relation to his account of exploitation. That was supported to some extent by a statement from social services. However, unfortunately, we couldn't get his full social services records because social services essentially said that they were so voluminous that they wouldn't be able to redact them in time. However, he did a really good job at giving evidence, and Grace was also part of that. We used her as an expert in that case and had psychological reports. However, it's quite clear from the jury questions that whilst they accepted his account of exploitation and accepted that the prosecution couldn't disprove the case, they made a judgment based on the reasonable person test that he could have made a different decision. And I think that shows really where race may well be at play, and we have to think about how we can work hard to ensure that we do convey to juries, or that we can put juries in the mind of the young person that they are essentially judging. So next slide, please. So the process, so in terms of steps for the defence, then we really, where our role really does come into play is really around challenging the decision to prosecute, and that takes huge steps for us in terms of ensuring that we have built a relationship with that client, that we've gained their trust, and that we're able to create that narrative that we can put before the court or in representations to the CPS. So the process starts with the NRM. If I could have the next slide, please. And just to remind everyone that despite the Bracani, the NRM is still important. This is where our work begins, as the first hurdle we have is ensuring professionals working with Black and brown boys and girls see them as vulnerable and potential victims, and make good quality referrals that establish that narrative. We've heard from Janine Davis in our earlier seminar, which looked at adultification, that Black children are less likely to be seen as vulnerable and potential victims, and therefore professionals are less likely to make good quality referrals that establish that narrative. We were hoping to use Janine as an expert witness on adultification and CC in a recent case I had of a 19-year-old Black female. She'd been charged with multiple offences involving the bringing of drugs into prison, and despite her having a long history of CCE and CSE, the decision was still made to prosecute her. We were referred the client at the point of charge, and the police officer stated in the IDPC, B has claimed that she is a victim of modern slavery. However, this has been reviewed by a DS on that unit who states that there is no evidence of this, and more points towards a criminal lifestyle. This matter is therefore closed, and this is not something that needs any further investigation. So that was the starting point of an officer who should have been a first responder, who should have considered NRM in this case. So the minutes of the conclusive grounds decision actually set out that the period of exploitation could be determined to be over a period of 3 years in relation to this client prior to her arrest. She'd been flagged up as a high-risk missing person for a year prior to her mum receiving initial support from social services. She was found in cocoon properties across the southeast for a period of 2 years, and there are reports by other children known to social services that she was being used to perform sexual acts to groom others into exploitation. Eventually, she was placed in secure accommodation. However, very quickly on her release and return to the local area, she was contacted again by her exploiters and given what they believe was a much less visible role of carrying drugs into prison. So there were significant failings on the part of the police and social services as the NRM referral was made at the point of arrest, and it still took 18 months before the decision to prosecute was made. So given that decisions not to prosecute seem to most frequently happen approaching a trial date, the next barrier is getting your client to engage in any process that sees them as a victim and disclosing sufficient information to you to prepare a meaningful defence. Now, that also does feature in your representation. So if I could just have the next slide, please. So the next couple of slides set out the decision to prosecute and essentially what we can look to in terms of reminding the prosecutors about their duties. I'll go into that in more detail. So if you could just flick through the next two slides, please. Yeah, if we just leave it there for a moment. So lawyers have to recognise that a factor in them trying to prepare a meaningful defence will be considering the cumulative impact of systemic racism, which makes it less likely that Black children will disclose information to them, along with their deep-seated mistrust in professionals and the fear of reprisals and having been perceived as a snitch. So you will have to do a lot of work by obtaining social services records, school records, and building a rapport with your client in order to then be able to point to those records as points of discussion. So the recent case law really hasn't helped us. It started with DS, and essentially the Court of Appeal said that state proceedings should continue, and where lawyers were arguing that there had been an abusive process by a decision to prosecute, and that the issue of whether the defendant is a victim of exploitation is a matter solely for the jury. Next slide, please. We're helped out by VCL briefly, which states that there must be clear reasons for disagreeing with the competent authority, so that can be cited in representations, which will force the CPS to consider whether they should be prosecuting at all. And then when we move to Bracani, could I have the next slide, please? Where Bracani completely discredited the single competent authority. It discredited independent experts and essentially gave carte blanche to prosecute. So literally within days of this judgment, we were then receiving, we'd made written representations and we were receiving letters back that simply stated, we've read your representations, but in light of Bracani, we are proceeding. Now, I've raised this on many occasions in meetings with the CPS, and I've been given a very clear steer that all decisions to prosecute must fully consider representations and must consider an NRM, and matters should be adjourned in order for the NRM process to take place. So you have to really push back on when you receive a letter of that kind, and essentially you may have to look at going above that reviewing lawyer, making representations directly to the legal manager of that area or the district prosecutor. And then we have AAD. Next slide, please. Which essentially, if we could just move on to the next slide, please. Can we move on to the next slide, please? The case of AAD overturned DS and upheld Bracani, but it provided guidance as to what a suitably qualified expert in trafficking could address. And so whilst we are being limited by all of this case law, and Grace can explain this further, there is still the opportunity to put expert evidence before the court. And then I think it depends on the court as to how much how much of that evidence they allow. I think that it's important that we still do this, and I think that some people are interpreting the law strictly and feel that experts cannot be used. But I still, as I said in the case that we did just a couple of weeks ago, the expert evidence, I think, was still very compelling before the jury, and still educated them on many factors which were way out of scope for them. So I think it's important that we continue to do that. So I think I've left a bit of time for questions.
Thanks, Aika. It's really clear that your experience on the ground is kind of second to none, and I know it's a depressing environment out there. You mentioned in your talk how distrust of authority is heightened for Black, Brown and racialised clients. Can you give everyone here some ideas of what you can do as a lawyer for the child if that child doesn't want to say that they've been exploited? Are there ways to get around that, or do you have to?
Yeah, so initially, the very few clients that I have come out and said I'm a victim of modern slavery at the first meeting. So I think in the first instance, you have to be talking to professionals really early on, and any family members or trusted adults for that young person, to try and get a bit more information about what was going on. You have to scrutinise the circumstances of their arrest and see if there are any kind of clues that might point to modern slavery. So we've had young people who are just, arrested in a car with an adult. They think they've got, a load of drugs and money on them. The adult doesn't have anything on them. We had a very vulnerable young person who was simply arrested in another borough, but from the outset, his mum was very clear to us that he would never have gone there. That wouldn't be something he could do, that the only way that he would have been able to get there is if somebody had taken him. We've had young people who've been placed in children's homes and then within days of being placed in that children's homes have been arrested in other parts of the country. So, I think you've just got to be really alive to the potential of exploitation from the very beginning. And then you can say to that young person, look, I think that there's more to this. I think something's going on here, and I want to look into it further. Obviously, you have to explain that there is a potential defence. I've had clients from the outset saying that's not happening to me, and I have said, well, look, at this stage, the youth offending team or your social worker or somebody else thinks it might be, so we're going to let them make a referral. Will you let me do that? And you take it stage by stage, and then I think as they move through the process, often you're able then to develop that trusting relationship, and also as long as you're really clear that you're going to protect them in the process. So I've had many young people who said, well, what's going to happen to me? People are going to think I'm a snitch. We've had cases with co-defendants where we've had to write letters directly to the judge to state that we're not able to, it's likely to be a modern slavery defence, but we're not going to state that in open court at this stage because the co-defendants being present. Lots of kind of strategic moves, I would say, but with the young person at the heart of it, thinking about what is of most concern to them, and more often than not, it's not going to be the same things that are of concern to you.
Thank you, that's really helpful. And I suppose what you're really saying is look closely at each case and pay attention to what might be exploitation, but also be creative in how you litigate those issues. So there's no kind of fixed answer. There's a question here from someone in the audience. How can a barrister best support solicitors and child clients in CCE cases, considering the barrister won't necessarily have the time to build a relationship of trust with the client? So how can they be in that supporting role?
I think it's it's so often barristers give solicitors checklists, as much as it's annoying for us. I think it's, you know, because you are slightly at arm's length, and, you know, as a solicitor, I'm often like, does this barrister have a clue what I'm actually dealing with, just trying to build a relationship with this client, let alone giving me a shopping list of things to do. However, it kind of is helpful, I think, we have almost come up with a formula that seems to have been fairly successful. So despite us having the first conviction of a modern slavery case last week, that client was actually given a sentence that was significantly less than he would have got had he pleaded guilty at the PTPH. And that is because I think the judge was so sympathetic to what had been put before him throughout the trial, that he ended up with a sentence, a really low sentence. So so I think in terms of what barristers can do, it's setting out the formula, which is essentially request social services records, request school records, obtain a psychological assessment, instruct a CCE expert. Those 4 things pretty much from the outset have been the recipe for our success in all of the other cases that preceded this recent one.
Thanks. A question from the audience, which I think is quite similar to the first question, but probably a bit more nuanced, and so there might be a more nuanced answer. They say, I've had youth defendants who do not want to admit to being exploited, and they'll instruct me very clearly not to rely on social services reports or use those to defend them. It's then very difficult to prepare their case. Can you give any advice on those situations?
I have had young people say that, and in most cases I've managed to get them at least to allow us to run the case up to the point of trial. It will become an issue if they have to give evidence, and I did have a situation where in the youth court, where a young person was prepared to proceed with the process and allow us to make representations and do our best to try and get the case dropped. But when as the prospect of giving evidence approached, he was adamant that he wanted to plead guilty, and there was, you know, nothing I could do really at that point. But I think, but in most other cases, most young people, they may say that at the outset, but if they allow the process to begin at least, then they will work with you. But obviously, you know, there might come a point in the case where they would simply refuse to give evidence, and the whole case rests on them giving that account.
Thanks. Okay. I've got a question that I'll ask Grace as well, but it's from the audience that says, luckily, currently the Sheffield courts haven't challenged the NRMs this far, but I am aware that this may occur. Who, in your experience, do the court consider as a viable expert in trafficking?
Well, we have one on the panel who is getting increasingly busy, but there are very few. That's the point. I think there are very few. And yeah, I've only actually used Grace. So there were others that we were trying to contact in relation to a case where Grace couldn't be the expert, and all of them had backlogs of months and months and months. So yeah, and I don't know. I haven't challenged. I haven't had to deal with another expert, but Grace is currently being accepted, but I'm sure she can explain to you where she hasn't been and how that's been difficult.
Great, yeah, we'll ask Grace after she's spoken. There's another question here from the audience. You've talked about juries and trials, but a lot of these cases will be summary trials. Do you use the same approach in a summary trial in the youth court on a county lines case than you would in front of a jury?
Yeah, exactly the same. And in fact, I found that a lot of the time those cases have been dropped much earlier stage, and often if you do representations at the outset and then do representations literally the week before the trial, and then and remind prosecutors that the duty is upon them to prove, well, to disprove essentially the position, then that often is quite successful in terms of getting rid of summary matters, because they often at that point often think, what are we putting before the court that disproves this?
And I'm kind of combine just two questions here because we're slightly coming towards the end of time. So it's really about the time that everything's taking around the NRM. So a social worker has put in the chat that it's taking months and sometimes years for decisions to be made on NRM referrals, and what can professionals do? Someone mentioned that there's a pilot project where a couple of local authorities are now responsible for those decisions rather than the Home Office. But is there anything as a lawyer you think can be challenged on the delays in the process?
I think it can be. This is something Danielle is particularly interested in, so she may want to touch upon that. Yeah, so I think I'll leave that to her. But
brilliant. Well, I might ask Danielle if you want to come in on that question now. That would be amazing, just about the delays in the system and what lawyers can do.
Well, I mean, the reality is nothing for the individual case, but I was talking to Ica about whether there would be any merit, and I haven't taken any steps in relation to this, but whether there would be any merit in a class action because of the delays, because we're just put in this invidious position where we've got a system that's been set up that's supposed to prevent these young people from having to relive the trauma when they give the evidence. I mean, the case that Ica was just talking about, where yes, we did get a good sentence overall, he'll still have a conviction against his name, but more than that, you know, really difficult for him to have to sit in a room full of people he doesn't know and talk about being vulnerable. I mean, I talked to him a lot about toxic masculinity, and that's quite a, you know, prominent feature in child exploitation cases. But, you know, the NRM was designed to prevent those people who had been traumatized from having to be re-traumatized in order to avoid you know, the criminal process in its entirety. So it seems absurd to me that the delays are actually what is preventing that from happening, and I think that there's a responsibility on the government to do something about it. It's not my area of expertise, but I think me and Ica, Grace, Gary, probably everyone that's on this call has had enough experience of this to know that it's a systemic problem. It's not just the odd case here and there. So yeah, I mean, something has to be done, whether a class action is the right way or whether just a single challenge would be sufficient. I don't know, but it'd be good to get heads together to discuss it.
And I think in terms practically, what we tend to do is you have to constantly chase the social worker to chase the single competent authority, and then and it's also possible through the social worker to essentially have your name on the record so that you're kept updated. And they do seem to respond when there is a trial date imminent in terms of getting that case, getting that decision.
Thank you. I think that's really interesting, and to look at a kind of systemic challenge, as Danielle says, whether for an individual or for a group of people. And perhaps if people are having delays that Danielle mentioned that have significant emotional consequences on clients, those can be sent into YJLC through their advice line to look at whether there's a potential systemic challenge within that. And I think everyone at Just for Kids, and as Danielle says on this call, will be happy to think of a broader systemic challenge. Thank you, Ica, and thank you, Danielle. I'm going to move on to our next speaker now, who is Dr. Grace Robinson, the expert that Ica mentioned. Grace is the founder and CEO of Black Box Research and Consultancy. She's worked on over 100 modern slavery cases nationally, comprising drugs and weapons offences, fraud, burglary and robbery. Grace completed her PhD on urban street gangs, child criminal exploitation and county lines in Merseyside, and is able to offer contemporary insights in an area with little existing literature. Grace was previously employed by the University of Nottingham Rights Lab and led on projects exploring the impact of COVID-19 on county lines and examining the intersection between cognitive impairment and criminal exploitation. She is currently undertaking a course on identification, support and care for victims of modern slavery and human trafficking at St Mary's University, and continues to share her research across the country, participating in podcasts, radio interviews and documentaries. Thank you for joining us, Grace. It's great to have you and to hear your expertise. I'll hand it over to you.
Thank you so much, Shawneen. Also very, very nervous after that introduction. So today I'm going to talk about county lines and my experiences of being an expert witness over the past almost 2 years now. County lines is reported to be the most common form of criminal exploitation. I'm not sure how much I agree with that, because I think that criminal exploitation in localities is much more hidden and often more overlooked. But it's certainly something that's grown in severity since I started researching in 2016. Of course, some of that can be attributed to rise in awareness and better reporting methods, but the scale of the issue cannot be understated. Since 2021, we've averaged around 500 county lines related referrals per quarter into the National Referral Mechanism. And in the first quarter of this year, there have been 530 referrals, accounting for 16% of all referrals into the National Referral Mechanism. County lines is essentially the migration of drugs from one location to the other, facilitated through the use of dedicated phone lines and dependent upon the exploitation of children and vulnerable people. But it doesn't solely comprise the supply of drugs in different areas. It involves sexual exploitation when children are forced to plug drugs, sometimes while being recorded. It's the theft of mobile phones, it's the burglary of cars, the stealing of somebody's identity, and the use of fraudulent documents. And it's also the perpetration of violence on others as a form of retaliation. It's arson, it's criminal damage, and a whole host of other crimes that children are frequently being exploited into. When I say children, I'd say the average age that I've worked with or come across have been between 15 and 17. But while I've been on this journey, I've worked on cases where the child has been 12. And when I was conducting the research in Merseyside, I also heard of children as young as 7 being exploited. If you have a look at the statistics, we also have an increased number of vulnerable adults being exploited. So victims of cocaine, drug supply, financial and sexual exploitation. And as well as that, drug deaths have reached the highest on record. Arrests of young people for drug offences are increasing. So around 1 in 3 people sentenced for supplying crack cocaine and 1 in 4 sentenced for supplying heroin are all under the age of 21. Between 2015 and 2018, the homicide rate among victims aged between 16 and 24 almost doubled, and knife injuries have also increased vastly by around 55%. Next slide, please. I think you've gone too far. I think that's towards the end. Go back to the 3rd slide, please, Shawnee. Sorry, the next one. That's my mistake. The next one. And the next one again. Absolutely anybody can find themselves being exploited and find themselves in the criminal justice system. And I've worked with victims from all walks of life, but of course there are certain vulnerabilities and characteristics that I come across on a daily basis which make people vulnerable to these situations. And most commonly they include mental health and learning disabilities, school exclusion, homelessness, experience of the care system and trauma. And I think as a society, we still don't have a good enough understanding of the impact of trauma on development and cognitive function in children or adults. You know, those who have experienced or witnessed things like substance misuse in the home, violence, abuse or neglect, having a relative in prison, grief and mental health issues are much more likely in adulthood to have come into contact with the criminal justice system, to develop certain conditions such as heart disease, asthma and chronic pain, and more likely to have committed violence in the last 12 months and have health harming behaviours such as substance use. The vulnerabilities that I come across often intersect with children having 2, 3 or 4 recorded at any one time. And frequently we see that those children are being ignored in a variety of different settings when professionals are faced with difficult behaviours like aggression, bravado or apathy. And these institutions are supposed to, you know, they're designed to safeguard and support children, but as a result, commonly, children are being criminalised far too often. Next slide, please. In looking at the causes of county lines, we can be easily distracted into believing that it's just social factors such as unstable families, delinquent peer groups, and it's a very clever narrative that places the blame on children and families rather than evaluating the structural and economic policies that have contributed to rising inequality, deprivation and poverty, and also the impact that those have on certain communities. So for example, since 2011, £1 billion has been withdrawn from youth services and £7 billion has also been withdrawn from schools. A review of school exclusion in 2019 identified that during the 2017 and 2018 school year, 7,900 children were excluded from school, and that equates to around 42 children every school day. As well as that, support for punitive criminal justice responses under both Labour and Conservative governments have increased, and this has led to heightened levels of stigma, the development of more prisons, and increased prison populations to fill them. Not to mention the incredibly oppressive system, which allows Black and brown children to be policed, to be harassed, excluded, exposed to drugs and alcohol, violence, provided with reduced opportunities, and imprisoned at higher rates than anybody else disproportionately. Next slide, please. One thing that I feel that it's important for me to say is that county lines is not solely a Black issue. And I can say that because every single young person in my Merseyside research was white. However, in London, it disproportionately impacts Black and brown communities. And with that, we see Black and brown children are subjected to increased profiling, stereotyping, and increased stop and searches. In 2020, almost 320,000 stop and searches were carried out. And for every one white person stopped, there were 3.4 Black people stopped. Most of those resulted in no further action. Black and brown children are also excluded from school at a much higher rate than white children, and they also make up the majority of those in the criminal justice system. And these factors and statistics contribute to these communities having a lack of trust in services, to the extent that children who I speak to are terrified of their exploiters, terrified of the situation that they're in, but they are still unwilling to disclose their experiences to the police or to their youth workers because they believe that they will be prosecuted and because they don't feel like they will be protected. Next slide, please. So up until November last year, I was part of a research team at the University of Nottingham, and we worked on a 14-month project exploring the impact of county lines on the impact of COVID-19, on criminal exploitation and county lines. And for that project, we interviewed police, local authorities and charities, asking them about their experiences of working during the pandemic, the impact of COVID on the county lines model, and the impact on children and young people. And what we found was that by July 2020, June or July, the county lines model had pretty much returned to business as usual, with some minor changes depending upon where you were in the country. And I think one thing that really stuck out was that county lines varied from one area to another, and there was no sort of consistent model. It really did vary. People were still getting the drugs that they needed, but the model had become more hidden and the exploitation more severe. So, for example, we spoke with officers from British Transport Police, and they were able to implement much more safeguarding measures as a result of reduced passengers on the trains. So they could pretty much stop and search or stop and speak to every single child that passed through the station because it was so quiet. Some of these children were equipped with disguises such as high-vis jackets and construction attire, and the reasons that they gave for travelling on the networks included going to funerals of relatives who had died of COVID-19 or attending food banks. And the response by perpetrators to that was to increase the trafficking of children in cars. And because of the risk of being stopped in those cars, children were taken to cuckoos properties with more drugs and were left there for much longer. We also found that there was an increase in the exploitation of children from local drug markets rather than networks trafficking children from major cities. And social media, particularly Snapchat, played a huge role in drug networks being able to identify those children and also map their journey to the drug market location. We had some particularly shocking findings when we spoke with youth workers based in A&E wards, mainly in the south of the country, whereby they would say things like the average age of hospital admissions dropped from 19 to 17, and they reported an increase in children aged 12, 13 and 14. And in terms of the injuries that they were seeing, they reported these to be much more severe. So, for example, they were coming across cases where children were having their fingernails ripped off, having their hair pulled out, and the amount of stab wounds increased from around 2 to 3 to an average of 5 to 6 per young person. Next slide, please. So I just want to reflect on some of the observations that have become more pertinent as I've progressed in this area. Experiences of trauma, marginalisation and school exclusion comprise almost every single case that I've come across. Exclusion particularly is the most common factor among those in young offender institutes, and I think every single young person who I've spoke to or worked with has been permanently excluded from school. Children in these situations and in these environments are experiencing extreme fear. They're fearful of the very real risk of violence and victimisation within their own communities, and they're also very fearful of authority and the results of disclosing their experiences to anybody. Too frequently, children are telling me that they don't leave the house anymore, that their mental health is suffering, and they've developed conditions like depression, anxiety, paranoia, and PTSD as a result of their experiences. And they can't see a future outside the cycle of exploitation that they're in. The quotes that you can see here on the slide are taken from some of the conversations that I've had with children and young people over the past 6 years. And I've been amazed at the amount of information that some children have shared with me. But I've also had some of the most heartbreaking conversations I think you could ever have. And I've heard children saying things that no child should ever say. The level of hopelessness and despair is so evident in these conversations. Authorities are still not hearing children when they say that they don't feel safe and they're still being failed as a result. Some are left homeless or in unsuitable, dirty and cramped housing. Many are in unregulated care homes and equally deprived areas. And many of these children are left on long waiting lists for mental health support. Then they're criminalised, at which point the narrative completely shifts from safeguarding to punishment. Next slide, please. Sorry, that was the last one. As I said at the very beginning, I've been acting as an expert witness for the past 2 years, and I've worked on a variety of different cases. I've been really, really lucky in that while there's always been an argument over admissibility, I've never actually been stopped from giving evidence. That being said, you know, as Ike has discussed and Danielle will discuss, the recent case law of AAD and also Bracani has meant that it's been a constant learning curve for me trying to navigate these pieces of case law. And it's really sort of narrowed the parameters even further of what I can offer my opinion on. And I think that's compounded really by the fact that it's been so inconsistent from one court to another and one judge to another as well. You know, as most of you will be aware, the Modern Slavery Act is not an easy defence to use because it's very difficult to evidence. And the system really is against victims of county lines because perpetrators often make threats over the phone or in person, so there's no evidence of coercion. In instances where victims have been injured, they've been too scared to go to A&E, or they've not been allowed to by their perpetrators. So there's often no evidence of medical records. And because of the way in which they might present to police and members of authority, they haven't been perceived as the ideal victim, which has massively impacted upon their journey in the criminal justice system. So if I can just leave you with some recommendations that would make for a strong report or give much more chance of a strong report, my advice, similar to what Ika has said, would be to gather as much evidence as possible, as early as possible. And that might include signs of vulnerability. So for example, social care records, school records, medical, housing, psychologist report. And that doesn't just relate to lawyers, that also relates to those who are working with children and young people. So for example, are you in a care home? Can you see that there's a change in behaviour? Can you see that there are different items in possession, in that young person's possession? Can you see different cars pulling up to the house? Document everything that you can, because even little snippets like that would be very, very helpful. And, you know, finally, as Ika has mentioned, I can't stress the importance of instructing a psychologist as well. For me particularly, having a psychologist report to refer to that might demonstrate mental health issues or might demonstrate learning disabilities can often be the difference between a report that can assist or one that doesn't assist. So I think that I've left some time for questions, and thank you very much.
Definitely. Thank you so much, Grace. It's really interesting. You addressed a lot of the previous question that Ika passed over to you, but I just wanted to explore it in a little more depth because, as you said, getting a psychologist report alongside your report can be really helpful. And Ika was kind of talking about how they've used you in the cases and that other people are backed up for many months. What kind of credentials do you think could get someone accepted as an expert? So what are your credentials that allow you to be accepted into court?
So mine particularly, I did my PhD research focused on criminal exploitation and county lines, and then have since kind of been immersed in this area ever since. So I've done different research projects like the Nottingham one that I discussed. I'm still in touch with children that I was speaking to for my Merseyside research. And, you know, the qualifications have been massively helpful, but I think overall it's experience in that area. It's speaking with people who have those experiences. It's speaking to police. speaking to as many different people that you can, so that you build up sort of holistically an understanding of the context. So while qualifications have been very, very useful, I think sometimes, as long as you're in that area and you're speaking to the children in these situations, then I don't think there would be that much of an issue in proving that you are a credible witness.
And can I just slightly follow up from that, because there's been a question from the audience that they've heard of ex-police officers who might be considered experts in this area, and that some people leave the police force and go into consultancy work. Is that your experience? Do you know that police officers are being expert defence witnesses?
Yeah. So one of the people who mentored me mostly with the expert witness reports was a previous police officer. Of course, you might argue that there are issues with objectivity, but I think as long as you're dealing with the evidence that's in front of you and you're constantly trying to reflect on your own opinions and what that's based on, then I don't see there being much of an issue in terms of where you've come from in that situation.
There's a question here which you may, it sounds like perhaps it's a question for a psychologist, but you may be able to help the audience with. So in your experience, has the child giving evidence in court helped their case, or can it actually further traumatize them?
I think that would probably be one for a psychologist, really. I've got my own opinions, and I think, you know, the whole court process, for those who watched the very first workshop, the webinar that Justifica's Law have put on, you know, the video of that young person in the court scenario, even without giving evidence, you know, is a traumatic situation going into that environment where the language is different. People are talking about you, not to you, and you're very, very voiceless and powerless in that situation. Funnily enough, I feel very, very similarly in that situation, in terms of it's all very difficult to comprehend. So me feeling like that, I can't even imagine what a young person in that situation who has been through all of that exploitation and trauma, I can't imagine the impact on them. But my guess would be that it would traumatize them further in a lot of situations.
And I suppose the thing is, sometimes it's just essential to be able to hear from them, but how can you protect that re-traumatization? In fact, YJLC has got a trauma-informed lawyering guide that maybe Lily could put a link to in the chat for people who are thinking more about how their practice can be trauma-informed, because I know in Scotland, for example, it's very much, Scotland recognises that the process just of being in the courts can traumatize anyone, a child or an adult. But I think perhaps it's something we need to develop a bit more in England. So yeah, thank you for that. You mentioned when you were talking about social workers and care staff documenting any changes in behaviour, so that there's this record that can be used if it's needed further down the line. What do you think about those people coming to give evidence to court? Have you found that helpful in your experience?
I can't really answer that question, to be honest, because in most of the cases that I've given evidence in, it's been a psychologist rather than a social worker. So I haven't actually worked in any cases where there's been a social worker. I know that in some cases I have referred to the account of a social worker, and because that person isn't given evidence in court, that's been sort of rendered inadmissible, and I shouldn't be speaking about it or to it. But I can't answer that question, unfortunately. Sorry, Shanine.
No, don't worry. Maybe I can ask either Aika or Danielle to come in on that. Have you called family members or social workers to give evidence on the stand to support changes in behaviour at all, and has that been effective? Go ahead, Danielle.
Hello. I wanted to, in the case that me and Aika and Grace were all involved in, but I'm still reeling about from the last week. But we eventually got a Section 9 statement that that the Crown agreed. I think there is a reluctance on the part of social services for their employees to give evidence, and even that Section 9 statement, the social worker, in fact it wasn't a social worker, it was a care leavers personal assistant. But even then, they wanted this statement to be approved by their own in-house legal team before they were happy for it to be read. So I think that there's a reluctance. What I will say is that the judge in my trial said, well, I'll summons this person. If they're not prepared to come to court, I will summons them and get them there. And that might be the avenue that we perhaps have to go down if social workers are indicating that they're reluctant, because ultimately they hold the key to some quite important factual pieces of evidence that we might not be able to evidence in any other way. So if, for example, like me and Ica and Grace, you can't get the social services records in time, there are too many, I don't know, if you can't have it in a documentary form, then the only way really to evidence that there were periods of being missing, for example, or, you know, that the child returned home and had injuries, is going to be through the social worker. I think if you've got a child who's got family members, I haven't yet, but I personally would like to be calling those family members, because I think what it does is it turns a defendant into a child if you've got people who know them giving evidence as well. And so the case that I've been talking about, it was really great. For example, having Grace, she CVP'd in from Liverpool, but it instead of reading something to the jury, instead of just, you know, having a statement or some agreed facts about something, we were able to put Grace there as well, which just added a different layer. So thinking about, you know, making a case more palatable for a jury and helping them understand all of this. I think having different characters and different people introduced as part of the defense case is really important. But obviously you have to make a judgment call as well about the credibility of the parent, if you're talking about a parent, and, you know, just the ordinary considerations about whether someone's going to hinder or help. But yeah, that's my experience anyway.
Thanks so much, Danielle. I'm assuming, Ica, that you've got nothing to add to that. I've got a question from the audience here, Grace, which is less about the kind of criminal cases, but more about the kind of background and support for the children in these situations. So it says, "Hi Grace, I've read your work and it's been a great help to me on my research journey. I wanted to ask if you had a perspective on how debt bondage can be managed in the aftermath of a conclusive NRM decision and successful modern slavery defence. Too often our young people return to their estates only for torment to continue as a result of these debts."
Yeah, this is something that I come across quite a lot, and it's such a difficult situation to navigate, because obviously these children are stuck in these cycles of you know, repaying a debt, being caught for it, going to prison, coming back out. The only way that I think children can remove them, not even remove themselves, but get help to be removed from that situation, is to be moved out of the area. And I know that's very, very difficult, and often services are slow to respond to that, but you've just got children that are just remaining in this situation with no support and no help. And I think moving them, it needs to be a planned move, and they need to be involved in their own safety plan as well, because if they're not, you know, I've come across cases where authorities have tried to move a child and tried to move a family from one gang affected neighbourhood to another, where they're just at risk. So you need to include the children, the family in their own safety planning, and really try and move them out of the area.
Yeah, thanks. I think it's something that we've been looking at. It's kind of falls between the cracks of child protection law and criminal law, and there's nowhere to catch those children, which is a real problem in this kind of having siloed legal system. I've got one last question, Grace, if that's okay. We talked actually before we came online about concept of no grass culture that you put into your expert reports. Could you give us a little bit more detail about what you cover when you write about that in your reports?
Yeah, so children from these sort of environments and situations and communities have been conditioned in a way to believe that the aggressing is not an option, that they cannot speak to authority figures. You know, it's a part of coercive control by perpetrators to ensure that children aren't speaking to authority. It's worse, I think, in communities where they've got a distrust of authority. You know, if they're being over-policed or over-harassed, it's very, very difficult to get these children to cooperate. But they're very, very fearful of doing that, because not only might it result in prosecution, it also results in violent retaliations. And these children have seen firsthand what their perpetrators are capable of, and they're terrified of discussing anything. You know, even if they were to give over names to the police, quite often that young person won't be privy to the actual names or the wider network in general. So they don't believe that they're going to be safeguarded or protected by police. Quite often I've come across cases where children, when they have been arrested, their perpetrators have demanded to see evidence of that arrest and sort of tried to demand to see whether they've actually disclosed anything. And they will try and stay on track with the progress of that case to see if that young person has disclosed anything. And even when these children, you know, if they receive custodial sentences, there are associates of these perpetrators in their own prison who will continuously make threats that, you know, if you say anything, your family is going to be targeted. And that's the real risk to these young people. It's not the risk of violence to themselves, it's now to their family members. You know, cases where perpetrators have FaceTimed their victim or a child, only to be stood outside that child's home with a jerry can, threatening to burn it down. And the fear is real, and the lack of trust of authority is very real as well. And I think that is something that massively needs to be addressed in order to actually help children in these situations.
Thank you. It's really, I mean, I think most practitioners will relate to exactly what you're saying. This isn't a question, it's just a follow up, but do you find that that can be persuasive to judges or juries who may not know so much about that culture as you do?
I'd like to say yes. I do think they when you discuss the no-grassing culture and the fear and the debt bondage and the violence that takes place, I do think that there is an understanding, and I think that's becoming more and more, you know, as time goes on, we've got more of an understanding. So I think, yeah, it's really useful. And I think, you know, as I don't know if Danielle or Rika mentioned it, having somebody else maybe on the prosecution side to discuss the no-grassing culture, you know, a police officer, for example, would be so useful as well, because that's something that they experience quite often, is just no comment, no comment, no comment. But I think, yeah, the judges generally are quite receptive to it.
Brilliant. Thank you so much, Grace. That's really helpful. And I'm sure you'll be inundated with inquiries after this, but we really appreciate hearing from you.
My pleasure. Thank you.
If I can now turn to our next speaker, Danielle Manson, who's going to be talking about racism in bail and remand decisions. You've already heard from Danielle, but she is a barrister at Garden Court Chambers, where she represents defendants in all areas of criminal law and associated work. She has particular expertise in representing children and young people, and as you have heard, her and Ika and Grace do a number of cases together. Prior to commencing pupillage, Danielle worked at the law reform charity Justice as their criminal justice policy intern, where her research contributed to Justice's intervention in the Supreme Court case of R on the application of Hallam and Neelan and the Secretary of State for Justice, which related to statutory provisions governing eligibility for compensation for miscarriages of justice. Whilst she was studying law at university, Danielle managed the Innocence Project, working on a range of criminal appeals and applications to the CCRC. And in recognition of her commitment to the project, she was nominated for the Chancellor's Medal upon graduation. And she continues to sit on the CCRC's Stakeholder Forum as an established practitioner. Thank you for for talking through all these issues with us, Danielle, and it will be great to hear from you about racism in bail and remand decisions and what practitioners can do.
Thank you. Thank you for that introduction. Thank you for having me. I am sharing my own slides, so let me just try and share the screen. We are all, oh, I'm just getting a little error message. I don't think that we did a practice of this. So I just have to, do this. We actually had a tech run, didn't we, Shawneen, before, but I don't think
we didn't actually check the tech.
Yeah, exactly.
I don't know if Bianca or Lily are hosting. Are you able to share the?
Yeah, let me just quickly ping them over because I didn't even email them
Okay.
to everyone. So yeah, just give me 30 seconds to do that.
All right, no problem.
And then I can, someone can just share those for me.
Lily just said she's made you co-host, so you might be able to share.
Okay, let's see if that's worked, and then I can I share my screen? No, I don't think so. Just give me a second and I'll email them over, and then someone else can share them for me. And I suppose I'll just do a little brief introduction while they're being set up. Sorry, I've just sent them to Katya, so maybe she could help.
I'm sure Katya will forward them and Bianca will start. If
Yeah.
you want to start, we'll get them up as
Yeah,
soon
of course. Thank you. So yeah, as Shawneen said, I am a criminal defence barrister at Garden Court Chambers, and I'm coming up for 6 years call now. And I just say that just for a bit of context, because when I first started practice, I was in the youth court a lot. Now I'm a little bit more senior. I still represent children in the youth court, but I also do a lot more Crown Court cases representing children. And so I'm acutely aware for anyone on this call who is a pupil or who is very, very junior, that obviously you will be dealing with bail decisions when you go for a first appearance. So you'll be in the youth court, in the magistrates court, and you'll sort of be working within that framework. And obviously, for those of us who are more established, we clearly know that there's a very big difference to how things are done in the youth court and how things are done in the Crown Court. Sorry, I don't think my slides have made their way over. Just bear with me, everyone. But I wanted to say that just at the outset, just because I don't know. And in fact, it'd be quite interesting if people wanted to post into the chat or into the Q&A what sort of level practitioners are who are here, because I think that it's obviously it makes a difference when whether you're doing a Crown Court bail application or a magistrates court bail application. Just while I sort out my slides, I will send them through this way, because I don't think that they've been received in the on the emails. So just give me a second, and in fact it might just be easier for me to just trot on without the slides, and I will make sure that they are made available to you. So anything that I'm saying now, people who are on this call will get a copy of the slides later. So obviously the starting point with youth bail is that the bail application for children is different from the bail application that you would put forward for an adult, and there's a number of reasons that it's different. So firstly, our starting point is that the youth offending team, YOT, they have a duty to provide information and bail support, as well as a supervision package for each individual child. And so I'll later come on to sort of what my top tips are when you're applying for bail in the youth court, and when you're addressing issues of race and racism. And one of my tips is to sort of proactively engage with the youth offending team and social services, but they are under a duty to assist in that regard. Second way that youth bail sort of different from the adult regime is that if bail is refused in the first instance, the child will be remanded to local authority accommodation, and that's unless the section 98 or 99 conditions in LASPO are met. I'm not going to go through them, but I just say that I think to help people appreciate that there's a tiered approach. Obviously, there's bail granted, then there's remand to local authority accommodation, and then there's remand to the youth detention custody. And that is actually the position in relation to murders. So for those of you who will have gone to the ordinary magistrates court for an adult defendant charged with murder, you know that the magistrates court do not have the jurisdiction to consider bail. But if you have a child who is charged with murder, then the position is that the youth court or the district judge has to, at that stage, consider whether it is a remand to custody or whether it's a remand to local authority accommodation. It's not simply, oh, well, they have to go to Feltham. You know, there are steps that need to be taken even in murder cases. The other thing to consider and to always have at the forefront of your mind in relation to youth bail is that the court should always have the child's welfare firmly at the forefront of their mind. And obviously that's not really a consideration for adults. And the final thing that differentiates youth bail from adult bail is that you can make repeated applications for bail, even if there hasn't been a change of circumstance. And there's a case in my slides that you don't have, but that I have, where that's dealt with. So when these slides are circulated, you can have that up your sleeve if needed. So there are some helpful, although quite depressing statistics in relation to bail and children. So first statistic I was able to get from the youth justice statistics from April 2020 to March 2021 is that almost 3/4 of children remanded to custody eventually receive a non-custodial disposal. So again, I think we need to have that at the forefront of our minds when thinking about the importance of bail, and actually the fact that in the majority of cases, the ultimate outcome is going to be that someone, your child client is going to get a non-custodial sentence. And then in the year 2020 to 2021, the average length of time from the commission of an offence to when the case concluded was 219 days. And so again, that's a really long time for any child to be remanded. There were around 15,300 remand decisions. So that was, these are the statistics for 2020 to 2021. And there was an average monthly population of around 220 children remanded in youth custody at any one time. And then the last statistic from last year is that children remanded in youth custody accounted for 40% of the average youth custody population. So a really high number of children being remanded. And so then looking at whether there is a disparity because of race, well, undoubtedly there is. And here are the statistics that back that up. So in 2020 to 2021, more than half of the children in custody were from Black, brown or racialised groups. 29% were Black, and that's despite the fact that Black children only make up 4% of the general 10 to 17-year-old population. So a huge disparity there, if anyone was in any doubt as to whether this is a real issue or not. Over the last 10 years, the statistics tell us that the proportion of children from white backgrounds being remanded has seen a general downwards trend, but the number of Black, brown and racialised children remanded in youth custody is at the highest it's ever been for 10 years. So that's the context within which me as a practitioner and other practitioners on this call will be working in. Now, the starting point, I say, unfortunately, is that you have to assume that there will be bias. And that is going to manifest itself in a variety of ways. So the Crown may oppose bail on grounds which are informed by unconscious bias and or racial stereotypes. The bench or the judge might also make bail decisions and impose bail conditions on the basis of similar assumptions. And so really, if that's your starting point, my advice to you and anyone going into this is to be alert to racist narratives, especially the unconscious racist narratives, and that we all need to be checking our own cultural competence. What I should say is that the Youth Justice Legal Centre has put together a really helpful guide that deals specifically with bail and remand in the context of race and racism, and a lot of these tips are taken from there. So I'd encourage anyone to download that and have it at your fingertips. But really, that's the starting point. Now, I've been asked to help you guys think about what you can do to challenge racial disparity when applying for bail. And I suppose my first tip, or the first thing that I can say, is that firstly, you have to be vigilant. And like I say, you have to be looking for the unconscious bias, but you also have to be fearless. And I think that can be quite difficult for certainly junior members of the profession, perhaps pupils or people who have been sent, you know, to the youth court to cover a first appearance for perhaps a serious case that's going to go to someone else in your chambers. You know, it's quite difficult to address this sort of discrimination because it's so insidious, and it's not, I think, well, was it Kevin Hart that said it when he hosted the Oscars? You know, it's not go get me a lemonade racist. It's like sorority racist, isn't it? So I think he was like, you know, we like you, Rhonda, but you're just not Kappa. It's all that insidious, really difficult to put your finger on racism. And so, you know, how do you challenge those sorts of things? Well, firstly, I think that you can look out for risk assessments that are discriminatory in their nature, or that are based on stereotyping and unconscious bias, and also challenge adultification. And I think that's something that Gary will probably come on to talk about when he's looking at sentencing, but it's sort of a phenomenon that we have, I think we're quite used to within the criminal justice system, that you get a young, often Black male defendant who is not seen as the child that they are. I mean, I don't know what the reason for that is, and we probably haven't even got time to talk about it if I did, but you know, the reality is that these young boys are children. They're still children. And you know, we talked earlier about sort of generating rapport and generating trust, and how, you know, difficult it can be to talk to clients if they've been exploited. And I think this is something that kind of feeds into that they don't necessarily want to be seen as children. And the reality is that they are. And I often have to have really quite frank discussions with my clients. And I say to them in the cells, you know you don't see yourself as a child, but in the eyes of the law, you are. And so when we go into court, I am going to be calling you a child because you're under 18. And, you know, sometimes they find that difficult to get their head round. And, you know, I talked a little bit earlier about sort of the toxic masculinity and the fact that often these clients will feel like they have to, I don't know, you know, they don't want to show any vulnerability. They don't want to be seen as vulnerable by the courts, but ultimately that's what you have to do when making your bail application. And you have to show that these children are not threats, and that any concerns the court have can be managed in the community, because that's the real test, isn't it? So practical tips about what can be done when you're making your bail application. And look, you know, the reality is if you go there for a first appearance, you're not necessarily going to have at your fingertips everything that you need to make that bail application as good as it needs to be. But as I said at the start, you can make repeated bail applications when you're dealing with a child. And so, you know, these are things that you might not be able to get across if you go for the first appearance, but certainly something that you could go back when it's the bail call over hearing. So first tip, advance your bail application with reference to the specific circumstances of your young person, your child or young person. And what I mean by that is be as detailed as possible. So in your conference with them, when they're talking about what they're doing and they're saying, oh, they're at college and they're doing a course in plumbing, for example, well, you want the details, you want the name of the college, you want how long the course is going to last, how long they've been on the course, what sort of qualification they'll get as a result of it. I think sometimes when you're under time pressure, particularly in the youth magistrates court, you might feel like you need to rush through your conference when you're taking your instructions so that you can get into court and make the application. But really, I think getting as much detail as possible so that you can put that before the court is going to help. Again, I've put here on my slides that you guys don't have, secure as much documentation as possible. Again, really difficult if you're doing the first appearance and you're trying to deal with bail, but if any friends or family are there and they happen to have something that supports the fact that they're at college, and you can get a screenshot of that, and anything like that, get as much supporting documentation as possible, because the reality is, the starting point, as I said, is that there is going to be unconscious bias, and there is going to be, possibly doubt by the bench that you're addressing about what you're saying on behalf of your client. So I always think, well, I'm going to go in there with things that prove that this child's circumstances and situation are as I'm telling you. And that's one of the ways that I like to overcome this bias that someone might have, because I say, well, look, there's the proof. Again, as I said earlier, proactively liaise with other relevant agencies. So youth offending team, really important, and social services. Even if you don't have a looked after child who's within the care of the local authority, there might be a social worker somewhere in the background, or a care leaver assistant who knows a lot about the child that you're dealing with, that might be prepared to give you some more information over the phone that you can then say to the bench or the district judge, you can take it from me, I've spoken to this person directly, and this is what the position is going to be, if you're not able to get that supporting documentation at a late stage. I think one of the next sessions that YJLC are going to do is going to be on the gangs matrix, but you will often find that when you go to make your bail application, that some lazy prosecutor and some lazy police officer talks about the fact that there is intelligence from the gangs matrix on the child or young person. I get up in arms about this, because unless they're prepared to serve that on me and allow me to take my instructions on it, it's multiple, often inaccurate hearsay. So if there is a whiff of that in the MG5 that you get, or anything like that, I would really strongly be saying to the prosecutor before the case comes on, I need more information about this. You can't advance it without giving me any information about where the intelligence is supposed to have come from. So I personally really try and put my foot down as much as I can when it comes to references to the gangs matrix. Again, something rooted in, stereotypes and bias. Be vigilant. I've already mentioned that, but I think it's about listening to wording and tone. It's not going to be, no one's going to out and out say that they're racist, or they think that someone poses a greater risk because they're Black. It doesn't work like that anymore. So it's really about active listening, and then if you feel you can, challenging those stereotypes. And it's sometimes very difficult to have conversations with prosecutors before your case is called on. Obviously, the youth court sits in private. You can't just walk in and just grab the prosecutor and say, oh, can I have a quick word? But if they call your case on and you haven't yet been able to have a word or conversation with the prosecutor, I sometimes ask for time. Well, I often ask for time. I say to the bench, I just need 5 minutes, so you can work out what the prosecution position is. And I think that often prosecutors who are not in-house will get their instructions and will think that they have to sort of stick to them. So their instructions will be oppose bail for this reason. But sometimes if you can have a face-to-face conversation, if you can explain to them about what your child's personal circumstances are, you can sometimes make a bit of headway, and then the prosecutor might go back to the reviewing lawyer and say, look, I'm just gonna take a view on this. And you might be able to make some progress there. And then again, my sort of final tip was, remake the application if appropriate. So there doesn't need to have been a change in circumstance, but if you've advanced a bail hearing that, your young person has an address out of the area that they could stay in, but you didn't have any supporting documentation at the time, remake the application with that supporting documentation. Those are all the practical tips I think that I can give, but obviously it's a very, very difficult thing to challenge the inherent racism. We don't have any. So Gary's going to talk to you about the sentencing guidelines and about the fact that there's a lot of guidelines now that make explicit reference to racial disparity when it comes to sentencing. We don't have anything like that for bail. So it really is just about being utterly fearless when you're making your submissions and calling it out if you feel that you can. But I know it's easy for me to say when I've been doing the job for 6-7 years. I think it is harder when you're more junior. But that's the only way we're going to make a change. And the statistics, you can't argue with statistics, can you? It shows that there's a huge disparity. It's absolutely disgusting. But Shawneen, I try to do my best without being able to refer to the slides. But,
Thanks so much, Danielle. That's brilliant, and we can get the slides from you afterwards and share them around. So I really appreciate that. We are kind of at time, so I am going to move on, if that's okay, to introduce Gary Green. So last but of course not least, it's my pleasure to introduce Gary. Gary is a barrister at Doughty Street Chambers and has been a part of the advisory group on this project for Black, Brown and racialised boys. He has a strong sense of social justice and connection to local marginalised communities, which remains constant. He works for an array of voluntary grassroots organisations and is especially passionate about the welfare of children and young people. Gary's principal practice is in crime, and his experience is second to none and has been honed over many years in many important and high profile cases. It's great to see you, Gary, and we look forward to learning from you about how we can overcome racism in sentencing.
Thank you. If I was in front of my audience, I would be able to see who we had sat in front of me, and I'll be able to assess the experience. Danielle asked a question, and I did see some observations being made about people who were starting pupillage and so forth. So it may be that we have participants in this webinar of young barristers starting their life in the criminal justice system, defending and or prosecuting. We welcome you all within the criminal justice system. And Shawneen kindly outlined my experience and all of the fancy stuff about my work in criminal courts is all true. But in truth, the thing that has helped me to be far more balanced in the type of work that I'm doing and be able to speak on this particular topic is working within the voluntary sector now for in the region of 20 plus years, in fact. And that balances the work that I do within the criminal justice system on a daily basis, because it gives me a broader perspective of the young people that I represent, irrespective of their backgrounds, but particularly so of young Black defendants. And of course, it goes without saying, I am a Black male, perhaps not so young now, but once was. And my experiences within education, amongst the police and stop and search, still feel like yesterday. So to some extent, I'm able to balance and have some insight into the kind of experiences, but not generalize with those experiences of young people who I represent. And the need for an acute focus on Black children and Black young people within the criminal justice system does not need to be stated. And at this hour of the evening, I'm not going to do so. We've heard a number of statistics which have been identified by previous speakers, and I concur, and there is much research out there. Even the Home Office's research on the Parliamentary UK website, there are research and statistics about the disproportionate impact of the criminal justice system. There was a report, Justice's excellent report in 2021, which detailed those experiences in really sharp tone. And as practitioners, as new practitioners, and even as experienced practitioners, perhaps even more so, experienced practitioners, we have to be mindful. We have to be mindful that we don't conspire or contribute to the causes of disparity, and that we don't harbour, in particular, please note, please do not harbour a false sense of security, namely that because you are a defence, even human rights lawyer, that you have immunity from bias or discrimination. And the Youth Justice League Centre's guidance offers some very valuable and practical support and help and insight into these types of issues. And within the 20 minutes I have, I'm going to try and touch on some of the themes that are within the Youth Justice League Centre's guidance, and hopefully I can leave a short time after for questions. First of all, what I want to deal with is a theme that's been touched on by a number of the speakers and is most expertly dealt with by Janine Davis, who has been who spoke on this forum earlier in the week, and that's adultification. And I say it is most critical because it really underpins all of our relationship, or it underpins the relationship that we have with our clients. And adultification, a definition from the excellent Janine Davis, is where children are perceived as being more adult-like, and where they are seen through a lens of deviancy and not necessarily acknowledged as deserving victims, and where their innocence and vulnerability are erased over time. The ramifications of adultification are readily understandable. If we perceive a child as vulnerable, they are inherently innocent, and every effort is made to save them from punishment or to mitigate that punishment as much as possible. If a child is seen as more adult, they may be considered deviant, their intentions may be seen as deliberative, and they may be even be described as manipulative. An egregious example of which I'm sure a number of us, or if not all of us, have heard about more recently is the example of Girl Q. A number of professionals involved in approaching that young girl and searching her, and not one of those professionals perceived her as a child. Not one of them respected her humanity. So it's really important that we understand the impact and the consequence of adultification. Within the criminal justice system, for Black boys perhaps especially, the experience of coming to court is almost seen as a rite of passage and punishment inevitable. And so the consequences of adultification is ignoring the statutory protections that young children have, Section 44 of the Children and Young Persons Act, which is concerned with the welfare of all children who come within the criminal justice system, or the purpose of sentencing for young people, which has been to prevent offending. It's not supposed to be punitive in the same way that it is for adults. There might be a lack of effort or will to build a relationship, and it's really important that we build relationships of trust with our clients. There may be a failure to get important facts, or all of this can potentially contribute to harsher and more disproportionate outcomes for young Black defendants. And so to combat adultification, please, number one, be critical and aware of systemic failings as we've been discussed by a number of our speakers today, and which are documented in so many places, and that you really can't have no excuse to be able to identify just how the criminal justice system is dealing with young Black defenders and adult ones too. And also have some self-awareness, have any awareness of inherent biases that you may have. Look around in your social circles How are they made up? What alternative perspectives do you get outside of your own if you are not a young Black person? And frankly, even if you are, don't assume necessarily that your experience necessarily will give you the sort of insight that you necessarily need to deal with your young Black clients. And to quote Janine Davis, be courageous, lean into your discomfort. It starts with your own acknowledgement of your biases. So how to deal with sentences for young Black defendants? Well, I'm going to start even before the door of the court. It's so important that you build a relationship of trust with your clients. This is one of the factors that David Lammy highlighted within his report in 2017 that he thought contributed to disproportionality within the criminal justice system. And my tips are these: be honest. Sincerity helps to overcome barriers and may even overcome past experiences. Be a good listener. Be willing to be vulnerable and to learn and to say you don't know or you don't understand, and please explain. Acknowledge where necessary systemic flaws within the system. Don't paper over the cracks. Young people are as insightful on occasions about those factors which impact them as adults, and they can readily understand those people who are being sincere and honest with them. And don't make judgments. Ask, value, contextualize experiences, try to be holistic in your assessment of the young person. Coming on to deal with things that are said, submissions that are made about your clients. Prosecution submissions, I think Danielle has already dealt with this, but be conscious and aware of discriminatory observations that be made against young Black defendants. Debunk baseless myths. I had a case recently, in fact, in which it was an incidence of violence that happened within a club. And we had CCTV footage from the club, which highlighted some of the actions of people within there and those who were charged with offences. And a number of the young Black males within the club, in fact, women as well, were making gun signals to music. And I think it's long been known and accepted, even outside of Black culture, that gun signalling is not necessarily an indication that you wish to shoot somebody, but may be more to do with the music that's playing at the time. And this prosecutor in this case suggested that because my client was involved in gun signaling, he had an awareness and an intention to use a gun, which was completely nonsense. When it comes to evidence in cases and at sentences, be very conscious again of stereotyping, both in relation to music, in relation to what's said to be gang participation. Note that there are tests of admissibility for gang evidence. There's Myers and the Queen, there's the Crown and Jermaine Lewis, and there is a whole host of authorities which set out the test of admissibility for gang evidence. And where necessary, as has been said already, and that we've heard from the fantastic Dr. Grace, think also about expertise where necessary. When you have reports, pre-sentence reports in particular, remorse is considered to be a particularly important aspect of sentencing. Your client showing remorse is ordinarily considered a factor which benefits mitigation. But you may find on occasion, not always, but on occasion, you may find that there are some Black defendants who are less willing to express remorse and or apologise for the conduct that has brought them before the court. Please don't assume that a lack of an apology and a willingness to express remorse is synonymous with a lack of insight or even regret. It can reflect resentment. Resentment because of what's known as accumulated disadvantage. And again, this has been touched on by others earlier on. Accumulated disadvantage, which may have accumulated over a relatively short period of time leading up to their teens, by which I mean, for example, exclusions from school, which we've already heard about, disproportionate exclusion from school for Black boys, overrepresentation in stop and search figures, unfair denials of bail, and maybe even unfair outcomes in past sentencing hearings. All of these factors can contribute to a young person developing a fairly and understandably hardened perspective on how their lives about their life experience and what might be described as accumulated disadvantage. And if you wanted to know a little bit more about that, a sister organisation, as I shall call them, the Howard League, have produced also a guide on representing Black people within the criminal justice system, and accumulated disadvantage is dealt with in that. Be alert to the suggestion that young Black people have pro-criminal lifestyles. Be aware that in particular areas where young Black people might reside, that the social mix of people in that area may include those who are involved in gang lifestyles. And these young people may know some of them. And that's not because they are involved in the gang themselves or have ambitions to be involved in gangs. But young people who are involved in gangs have a social life too. They play sport, perhaps football in particular is what I'm thinking about. They may go to sort of local youth clubs or places where young people hang out. And oftentimes it's actually safer to actually know other people who are involved in gang lifestyles than not know them if you live in those particular areas. So don't make any assumptions that because young people may know or might be considered by the police to be somebody who has so-called gang associates, that they're necessarily involved themselves in gang lifestyle. Having previous convictions is a matter which can aggravate sentence by statute. Check antecedents, previous convictions for the avoidance of doubt, not simply for accuracy, but to check for past disposals. Where necessary, if you can obtain the facts of those past disposals, try and do so, because given the escalating nature of sentencing, it's really important that you identify if there has been a pattern of discrimination that that young person or child may have faced in the past. Look whether or not the sentences have been proportionate in the past. Look to see whether or not there have been appropriate community disposals in the past. Somebody's past will be a very good indicator of how the court might deal with them in the future. And it's really important to get underneath some of those past convictions, if there are them, and some of those past sentences. Whilst any first instance court is not a court of appeal, you may be able to make submissions about the particular circumstances of a past conviction or past sentences. Mitigation. Discrimination within the criminal justice system is rarely overt, but be alert and be mindful to the types of material that can assist you in terms of mitigation. There are plenty. There is the Crown Court book, and I appreciate that if you are junior practitioners just approaching your careers at the bar, you may not appear within the Crown Court as much as you will do in the future, I'm sure. But the Crown Court book, Bench on Equality, gives a number of helpful tips and guidance about discrimination within the criminal justice system. I think Daniel has already touched upon the fact that many of the sentencing guidelines now expressly identify the fact that young Black people within the criminal justice system are dealt with disproportionately. And also, I've already mentioned the Howard League's guide on defending young Black people within the criminal justice system. And there are a whole wealth as well of socio-legal reports. Justice, as I think I've mentioned, Tackling Racial Injustice, 2021. There is the YMC report on young Black people's experiences, 2020. The Stuart Hall Foundation completed a report, 40 years of racial inequality. And also another particular factor that you may be able to rely upon is reports from about the local authority. And I don't mean specific reports which are designed for your client. I mean to say local authorities collate figures and statistics about the kind of socio-economic makeup and crime, in fact, within their communities. go and have a look at some of those reports within particular areas. I had an important sentence to do for a client who was involved in firearms and drugs, a really serious sentence, not the type of thing that maybe junior practitioners will deal with. But what I did obtain was a report from the local authority dealing with the kind of socio-economic breakdown of Tower Hamlets. Also, personal reports, pre-sentence reports, order pre-sentence reports on occasion, even where the custody threshold may have been passed. Don't think that it's always a dead loss to have a report where a custodial sentence is inevitable. It can be of value. And there are a number of legal authorities as well, which deal with issues about maturity of the child. So where a young person may be being perceived as more adult and older than their years, note that there are a number of authorities nowadays, the Crown and Peters, the Crown and Clark and others, the Crown and Daniels, where the age of the offender is not the sole factor that the court will consider. They will also look at their maturity. So if you have a young person who's maybe that bit older, but is still developing in terms of their maturity, it's really important that you understand that and you have a report that highlights that, whether that's a pre-sentence report or on occasion a psychologist report. Personal mitigation, moving through matters quickly because I know that my time is short. It's already been dealt with. Consider the issue of exploitation. I think that's been dealt with at some length, so I won't deal with that. I've already said consider the issue of accumulated disadvantage, schools, employment, housing, police. And consider also any connection that that young Black person may have with a local grassroots self-help scheme. There are lots of them around. I've worked within them for a period of 20 years. And some of the people who are involved in running these grassroots organisation schemes have a real handle on what's going on in the community and the sort of issues that young people face and the local challenges. And lastly, just because I'm running out of time, I want to say, don't be afraid to identify the elephant in the room. Don't be afraid to confront racism head on. You have the support of the Sentencing Guiding Council. You have the support of Crown Court bench books. You have the support of fantastic organisations such as the Youth Justice League Centre, who produce well-respected reports. Where necessary, bring them out, rely upon them. If you don't feel like you have the courage to say it, rely upon authority that's well respected within the court system and defer to it where necessary. I do have some notes and I will forward them in due course to the Youth Justice League Centre, so perhaps they can be read and considered thereafter. But that's all I shall say for now.
Thank you so much, Gary. It's obviously really important at sentencing. I've got a couple of questions if you're happy to answer them.
Yes,
one is from me, so I'm going to start with that. Because you mentioned Section 44 of the Children and Young Persons Act and the welfare principle. And I was just wondering, in your experience, do you think that criminal court judges really understand their duties under it? Because in my experience, I found that they've kind of tended to want to see everything through the lens of criminalisation rather than welfare.
Yeah.
And if so, how do you raise that with the judge in an effective way?
I mean, I think if we're dealing with children who are, within the age of being a child, not only do you have the welfare principle, but you also have the important difference in terms of what the sentencing is supposed to achieve for children. So they've got a statutory duty to prevent offending. This is not just about punishment in the first instance. Insofar as beyond that is concerned, obviously pre-sentence reports should help, but they don't always. I can think of a recent example that I had of a young person who'd been involved in a firearms offence and had a terribly disproportionate and difficult background and life, and was plainly seen by the probation service as far older than his years. And what they ignored with that young person was how he had gained support from some of his associates, because he didn't, regrettably, he didn't have too much family support. And it was really being able to see behind the facts that were laid out in that report and to get to the nub of what it was that contributed to that young person's behavior. And really, it was a sense, it was immaturity in part. It was a lack of support. So it was, in a sense, it was really important that I brought the court back to seeing this young person and seeing them in full context, a lack of family support, for example, and which reminded the court that they were a young person and they were vulnerable and they needed that support. So it's really important to build that relationship of trust with young people, to try and get from them, really important to get the facts from them and to identify those features of their lifestyle, which show that still they are vulnerable and they are a child.
Thank you. And then that kind of neatly follows on to the next question that I have here, which is, have you ever called an expert witness to give evidence on the multiple disadvantage that might have caused the criminality? Or do you solely rely on the pre-sentence report? And if you have had an expert witness, how do you think it helped?
I haven't called an expert witness for that particular fact, save that I suppose I could be said to have called a quasi-expert in as much as, and I think I touched upon this earlier on, bringing people who are involved in voluntary support groups within the local community, who usually have a huge amount of experience of dealing with young people within that particular area, who can speak to the general difficulties that those young people experience, whether those experiences are, exclusion from school, whether those experiences are disproportionate stop and search, whether they are sort of difficulties within the local area where that young person resides. And I think that we can sometimes be dismissive in this, what's considered to be a fairly kind of superior profession. We can be dismissive of those people who work within kind of local community voluntary organizations who have a wealth of experience of dealing with young people in those areas and can speak directly to the issues that young people more generally face. But even if you don't have somebody who you can identify in that way, as I said, there are a wealth of reports now which are capable of setting the background for the types of experience that young people, young Black people in particular, face, and you can place them within the context of those experiences, those reports.
Thanks so much, Gary. And yes, I completely agree with you. There's a question here from the audience. Do you escalate concerns about racism or bias in written pre-sentence reports to the relevant youth offending team or probation area, or have your solicitors ever done that?
Well, I've done it. Actually, I've done it. And anybody, if there's anybody on this participant who knows me, I can be very passionate about the circumstances in which representations are made about my clients. And I've spoken directly to authors of reports about why they framed the narrative about my client in a particular way. And as I think I spoke about, the most recent example of that was a young man who had been through a traumatizing experience. I won't detail what it was, but it was a very traumatizing experience. He had lost contact with his family, and his support network were described by the probation reporter as having gang lifestyles. Now, that may or may not have been accurate, but what that report writer failed to do was to see how those so-called gang members had effectively developed a relationship of confidence and trust with this young person, and were effectively his support network. They were effectively his family. And so I spoke to the probation officer about the manner in which she had placed that particular young person in a sort of in a lifestyle of criminality. And to be fair, they took on board the observation that I made and was willing to actually come into court and speak to aspects of the report. So, you have to be careful about how you manage that, both obviously with the probation service itself and in service itself and in court, because for the most part, the probation service and the youth offending service are seen as providing a valuable service to the courts. And, you know, direct criticism of them during mitigation will not go down well. So you have to praise it by effectively indicating that, you know, you're so grateful for the valuable support that the youth offending service or probation have provided, but you are concerned about this or that aspect of the report. So it to some extent, it's a feature of advocacy about how you approach it. But certainly don't be afraid to contact authors of the report. Within modern practice, we get the reports before the day of sentence. We always used to get the reports on the day of sentence, probably, you know, 10 minutes or so before your hearing's called on. But because the system's been digitized, leastways in the Crown Court in any event, you get those reports at least a day in advance. So you've got the opportunity to try and contact the author of the report.
Thank you so much, Gary. Sadly, we've run out of time, but thank you so much to all of our speakers. It's been another fantastic session, and I really think that, and I hope everyone's practice will develop because of that, whether they're lawyers or youth offending team professionals or social workers or any other professional working in the youth justice system. So obviously a huge thank you to all of the contributors who took time out of their busy schedules to be here. Please do join us for our final session in 2 weeks' time. It really relates to what Gary was talking about, a bit about the gun signalling in the club, where Keir Monteith, QC, will be exploring the damaging use of rap and drill music as evidence of criminality. When we worked with the young people on this project, we really noticed that a lot of white music, which announced criminality, was never shown as being a criminal act. And when you talked, Gary, about the gun signalling, I was thinking in Charlie's Angels, weren't they all signalling as guns? But obviously that's never seen as an act of criminality. Correct. So, you know, we can...
vintage to remember Charlie's Angels, but yeah.
I'm just showing my age. So, yeah, I think that's particularly interesting as well in light of the recent news report of Project Alpha, which is that Home Office initiative that scours social media to find people associated with drill music videos without their knowledge. Slightly shocking, but maybe not surprising in our current political climate. We'll also be joined by Lana Adamu from Liberty, who'll be discussing the gangs matrix, and Enya Quinn, who's an expert on culture, commercialization and prosecution of Black UK rap, and Zara Hussain, who's been instrumental in writing these guides, who will talk about an issue that was really important to the young people that we work with, about just highlighting the difference between the UK and the USA and not always thinking that we are the same. That their point was that actually the UK is more insidious in its use of racism because we don't have an accepted history of slavery, whereas everyone in the professional system in the US has to accept the history of slavery. So we're coming from a kind of worse platform in their minds. So I'm sure that session will be brilliant, just like this one. And we really hope to see then. So thank you so much for everyone who stayed a little over time, and thank you so much to all of our speakers. See you soon.
Thank you.
Bye.